Welcome to Policy Pulse. In this particular episode, we'll discuss one element of the legal profession. As you probably know, that legal profession has been adopting slowly the AI into its practice, especially the practice management software that they use. So the question is that there is a claim by the vendors of the software and even the law firm themselves, which I mentioned in my other AI related topics episode, that there is a significant savings and efficiency has occurred due to use of the AI. What used to take the lawyers for 10 hours, now they could do it for 2 hours. So the central question is that those savings, because the legal fees are, as you know, quite expensive. A mid-tier lawyer would charge somewhere from $400 to $600, so it adds up. So the issue is that savings that the lawyers are having, are they passing those savings to the consumer, or they're keeping it in their pocket and profiting the savings? So let's dive in. Almost every Canadian has hired a lawyer or needed one and could not afford it. Perhaps you needed a real estate transaction to be closing by the notary public or lawyer, a custody dispute, a wrongful dismissal, or you needed to prepare some estate planning documents, whatever the case may be. And almost every time, the experience feels the same. It's expensive, it's unpredictable, and largely out of your control. Today on Policy Pulse Canada, we're going to ask a question almost no one in government is willing to ask. And nobody in the media is worrying about it either. Why does Canada's legal system protect the profession more than it protects the public? Most Canadians assume that when they hire a lawyer, they are protected the same way they are when they hire a mechanic, a contractor, or a financial advisor. They are not. The legal profession in Canada, unlike virtually every other profession that touches consumers, largely regulates itself. The government doesn't set legal fees, the government doesn't license lawyers directly, and if you dispute your bill, the path to resolution looks very different from anything else you buy in this country. Our central question today is that system still fit for purpose in 2026? Because two things have changed that make this question more urgent and relevant than ever. First is access to justice. The statistic on who is and isn't getting legal help in Canada are striking. The second is AI, which is transforming how legal work gets done while the billing system stays frozen somewhere in the last century. To understand why the legal profession works the way it does, you need to go back several hundred years. The profession evolved from medieval England. Two groups emerged: barristers who appeared before judges in court, and solicitors who managed client affairs and prepared documents. Over centuries, profession gained special privileges: the exclusive right to appear in court, self-regulation, professional secrecy, and independence from government. And the justification made sense at the time. Lawyer must be independent from government so they can defend citizens against the state. Although that's mostly related to criminal matters, but for civil matters, that's a different ballgame. And I want to make that distinction here. You can't have state licensing and controlling very profession that challenges the state. That's the position the lawyers made. That principle was imported into Britain, Canada, Australia, New Zealand, and most common law countries. and it remains the foundation of how lawyers are regulated today. The question is not whether that principle was right when it was designed. The question is whether it's still the right structure for a modern consumer economy. When the people most in need of legal help are being priced out of the system it's supposed to serve. Here is how Canada's legal regulatory structure actually works. The federal government sets the broad constitutional framework, provincial governments pass legislation, in BC, the Legal Profession Act, and then, unlike almost any other regulated profession, the actual day-to-day licensing and discipline of lawyers is delegated to self-governing law societies. In BC, that's the Law Society of British Columbia. Here is what the Law Society does not do. It does not set legal fees. It does not license lawyers through a government ministry. And when a client disputes a bill, the Law Society cannot order lawyer to reduce it. The Law Society of BC's own website states that directly, and I'm quoting, "The Law Society does not regulate lawyers' fees. So if you have a disagreement with a lawyer over the amount of fees, filing a complaint with the Law Society will not resolve that dispute, and Law Society cannot order the lawyer to reduce his or her bill." End of quote. That's not an editorial comment. That's a direct quote from the regulator's own public-facing website. And it tells you everything you need to know about where consumers stand. So what does this system actually cost ordinary Canadians? Let's start with the rates. In BC, a junior lawyer typically bills between $250 and $450 per hour. A mid-level lawyer charges $400 to $700 an hour. A senior lawyer at major downtown firm um, can charge from $700 to over $1,500 per hour or more. In Ontario, rates for experienced lawyers routinely reach $800 per hour. Some specialists charge even more. Now, run those numbers against a real situation most Canadians face. For example, a 20-hour dispute at $500 an hour is about $10,000. A family law matter that runs 100 hours is $50,000. Complex litigation can reach six figures before you have even seen the inside of a courtroom. Now, here's what Statistic Canada found when they actually measured this. 18% of Canadians, roughly 5.4 million people, experience a serious legal problem in any given year. Among those who sought help, 71% never consulted a lawyer. And of those who tried to get legal help but didn't follow through, 37% said they simply couldn't afford it. That is not a gap in awareness, that is a systematic access failure. When more than 1 in 3 Canadians who tried to get legal help were priced out, the system is not serving the public it was designed to protect. Now, we definitely have a incentive problem. Now, let's look at the billing model that sits underneath all of this, because this is where the structural tension or the issue lives. Most legal work in Canada is still billed by the hour. As of 2023, hourly billing accounts for approximately 81% of the law firm revenue. And hourly billing raises an uncomfortable structural question. If a matter takes 5 hours, that's less revenue. If it takes 50 hours, that's more revenue. for the law firm? Does a billing model primarily based on time reward efficiency? Does it reward the client's outcome or the longest path to that outcome? Obviously, you can guess. Lawyers will respond, and correctly, that legal matters are generally unpredictable. Court creates a delay, opposing counsel creates delays, client change their instruction. Legal outcomes aren't like buying a product where you know what you're getting in advance. Those are legitimate responses, and we should present it fairly. But here is the next question. Does a client ever know when they sign a retainer what the maximum cost could be? In most Canadian provinces, not by default, pre-engagement cost estimates are encouraged but not mandatory in the way they are in comparable common law jurisdiction. And in 2026, there is a second question layered on top of all of these. One the legal profession has not yet fully answered. Let's look at AI tools are already inside Canada's largest law firms. Practice management platforms, which are the legal profession, they use the software to manage their practice, such as Clio, Leap, Cosmolex, MyCase, are integrating AI that can summarize documents, draft correspondence, review contracts, search case law, extract key facts, and produce first draft of pleadings. Matthew Peters, a partner at McCarthy Tétrault, one of the largest law firms in Canada, said this about using AI tool co-counsel. Instead of taking 10 hours to dig around, you may do it in 2 or 3 hours. End of quote. That's a 70 to 80% reduction in time on a task that would previously have been billed at a full professional rate. Now, here is a question the legal profession has not fully answered. Whose savings are those? If a lawyer previously billed 20 hours at $500 per hour, that's $10,000. If AI now allows completion in 4 hours at $500 per hour, that's a $2,000. Most consumers would say legal costs should fall. Some firms have argued differently. You're paying for expertise and outcome, not the time you spend getting there. There is some merit to that argument, but here is a problem with leaving it there. The law firm's costs drop dramatically. The client has no way to verify how much of the bill reflects human work versus AI assistance, and there is no disclosure requirement to tell them. To look at further, the share of law firm revenue from hourly billing dropped from 85% in 2016 to 81% in 2023, and perhaps it will go down even more in coming years. A period of significant AI adoption. That 4-point shift represent enormous productivity gains that by and large stayed inside the firm. The policy question Canada has not yet answered: when AI reduces the cost of delivering legal services, who does that benefit belongs to? Here is something almost entirely invisible to the average client. When you receive a legal bill today, it lists time spent and the task performed. What it almost never tells you is how much of that work was done by a lawyer and how much was done by AI. If a junior lawyer spends 1 hour reviewing document and the AI completed the first pass review in 20 minutes, is that disclosed? In Canada today, no. There is currently no requirement for law firms to separate AI-assisted work from lawyer-generated work on a client invoice. Now contrast that with two other common law jurisdictions. Victoria, Australia. Lawyers must provide a written cost disclosure statement before work begins, a genuine estimate of total cost whenever fees are expected to exceed $750. United Kingdom, the Solicitors Regulation Authority requires solicitors to publish their pricing prominently on their website in plain language before a client engagement engages them. In Canada, no comparable mandatory pre-engagement cost disclosure exists for legal services. Transparency is not a radical concept. Every other professional services the average Canadian buys comes with it. Legal services on that most directly mediates your access to rights does not. Let's say you receive a legal bill and you think it's wrong. What's your options? In BC, the Law Society offers a free fee mediation program. It can help resolve disputes without going to court, and the process can be done remotely. That is a useful resource, at least on the surface. But the program is voluntary for both parties. So it's a waste of time if you cannot resolve it. The Law Society cannot compel participation, and as noted, it cannot order any reduction in the bill. For formal relief, clients can apply to the BC Supreme Court under the Legal Professional Act to have a bill assessed, a process that can itself involve court costs and additional legal time, and the client must be knowledgeable on the Legal Professional Act itself. Not being a lawyer could be challenging. Now, compare that to disputing a mechanic's invoice, a contractor's bill, a plumber's bill, or a realtor's commission. Consumer protection legislation exists. Licensing bodies with those profession have a enforcement power. In many cases, a dedicated consumer complaint office exists. The question worth asking is simple. Why is legal services, the profession that most directly determines your access to rights, subject to a weaker consumer protection framework than almost any other service Canadians routinely purchase? This isn't a new problem, and it isn't an unsolvable one. Other common law countries have already moved on this matter. Australia, specifically as mentioned, Victoria, introduced mandatory cost disclosure requirements under the Legal Professional Act. Lawyers must provide written cost estimates before work begins when fees are expected to exceed $750, as I noted earlier. Independent legal cost assessors, separate from the profession, can review and modify bills. The United Kingdom went even further. From October 2023, the UK extended its fixed recoverable cost regime across civil matters, making legal costs more predictable and capped in a wider range of cases. Solicitors Regulation Authority requires transparent published pricing. Both countries have maintained the core principle of lawyer independence from government, which means the argument that we cannot regulate legal fees without threatening lawyers' independence is not supported by evidence from our closest legal cousins, so to speak. You can have a strong consumer protection and professional independence. Other countries have proven it. It's about time that Canada also move in that direction. Rather than simply describing the problem, let's look at what reform could actually look like without threatening lawyer independence. Number one, mandatory fee estimates before engagement, similar to what mechanics and contractors already provide by law. Number two, mandatory fixed fee offerings for common predictable services like wills, incorporation, document preparation, uncontested divorce matters, simple document preparations. Number three, an independent legal services ombudsperson separate from the profession with the legal authority to review and reduce bill. Number four, AI billing transparency. When AI tools are used in a file, clients receive an itemized disclosure separating AI-assisted work from lawyer-generated work. Number five, consumer protection legislation governing legal services with built-in protection preserving solicitor-client privilege. And number six, task-based fee schedules for standard legal work so that a statement of claim, a simple motion, or a standard document review has a predictable cost range, the way the medical procedures and real estate commissions are commonly benchmarked and followed. None of these proposals require government to set legal fees. None of them remove lawyers' independence from the state that question. They bring legal services inside the consumer protection framework that every other professional services in Canada already inhabits. Okay, friends, so this is my verdict. Legal profession evolved over the years, and over the years it became more complex. And obviously, no one person, or at least ordinary people, can understand the full scope of the law and rules involved in it. That's why we need to hire a lawyer to help us guide through this maze. And court system is, of course, another area that only lawyers knows how to navigate, and that's why we rely on them. But in recent years, due to the significant cost of going to court, has prevented many people from access to justice and getting a fair resolution. So many times they will settle, they will withdraw, they will not proceed, um, and only rich corporations they can afford to hire big law firm and they can pay and win. So government is supposed to protect the people, but in this case, they seems to be totally silent, and our consumer protection branch is non-existent in this particular domain. And Law Society licensed the lawyers. They simply manage the legal fees structure. So there is a public don't have any say in it. If you go to a lawyer, they will say that's your rate. What option do you have? If you go to another law firm, the rates are all fixed. They're all aligned um, by the legal industry. So therefore, we don't have any choice. So let me know what else that you would like me to cover in future, because the legal profession is a big kind of domain, and I would like to take one piece at a time so it's digestible and easy to understand. Otherwise, we'll be all swimming in it. So thank you for watching. I'll see you in the next episode.